The following presentation is on why we should keep affirmative action. It will be presented by Aaron Serber, Ashley Wright, Jen Johnston, and Josiah Milner. To start things off, we want to learn what exactly is affirmative action. Affirmative action refers to policies that take factors such as race, color, religion, sexual orientation, national origin into consideration in order to benefit an underrepresented group in employment, education, and business areas. This is usually justified as countering the effects of a history of discrimination. Next, we'll look at a little bit of a brief background. The term affirmative action was introduced by President John F. Kennedy. In 1961, he issued Executive Order 10925, which created the Committee on Equal Employment Opportunity and coined the term affirmative action. This was a way of fighting discrimination that had persisted in spite of civil rights laws and constitutional guarantees. Next, we'll talk about the Civil Rights Act of 1964. This act contained a section on equal employment opportunity, and this was called Title VII. This title made it illegal for employers with 25 or more employees to fail or refuse to hire or to discharge any individual because of race, color, religion, sex, or national origin. The affirmative action concept was developed and enforced by President Johnson. In September of 1965, President Lyndon B. Johnson had Executive Order 11246 enforce affirmative action for the first time. In October of 1967, the order was amended to cover discrimination on the basis of gender. This term was originally envisioned as a temporary policy until all Americans had a level playing field. They wanted to be sure that blacks and other minorities had similar opportunities in education and jobs. This, however, led to reverse discrimination uprisings in 1970s. A famous Supreme Court case involving affirmative action was the University of California Regents versus Bach in 1978. Bach was a white male who was well qualified for medical school, but was rejected twice while the same school was accepting minorities with lower scores and GPAs. This was because of some admission policies that school had set when it came to accepting a certain amount of minorities. Bach won the case, but the affirmative action was still upheld.
There are several requirements to having an affirmative action plan. Each state has its own specific requirements. The following requirements are for the state of Washington. The state of Washington must include a workforce profile reflecting total employees and total employees sorted by group affected status. All affirmative action annual updates must show a comparison between the current workforce and the previous submission to show improvement, along with a goals report by job for each affected group showing where goals have been set. Also, a section containing a detailed narrative of the strategies to be employed to reach goals and a response to the Governor's Affirmative Action Committee recommendations from the previous plan or update. A lot of people think affirmative action requires certain quotas to be met to meet the plan's requirements, when really it does not. A quota would be literally setting aside a number of positions for an individual in a minority group. The court system actually watches over any questionable cases and have turned over any plans that they deem unconstitutional or quota-like. Affirmative action guidelines do not require quotas, but do require covered employers to meet certain goals and timetables for hiring and or promoting women and minorities. This can create an increase in competition for well-qualified applicants because employers are reminded to direct job postings towards minorities and women to increase applications for these groups. This issue has been very prominent in universities over the years. This is because quotas for admission can be confused with goals. These goals serve as targets reasonably attainable by means of applying every good faith effort to make all aspects of the entire affirmative action program work, and that the goals may not be rigid and inflexible quotas which must be met. Another argument is the supposed burden affirmative action puts on small businesses. Affirmative action can positively affect small businesses by not only preventing discrimination, but allowing the state and federal governments to favor women-owned and minority-owned businesses when awarding contracts, and to reject bids from businesses that do not make good faith efforts to include minority-owned businesses among their subcontractors. Affirmative actions can apply to all sizes of businesses and take several different forms. Often, affirmative actions are written into federal or state law. They can also take the form of voluntary plans or consent decrees. Occasionally, although rarely these days, a court will impose an affirmative action plan to remedy the effects of past discrimination, sometimes confused with regular use of quotas in affirmative action plans, like I explained earlier. Contractors with the federal government are required to have affirmative action plans under various federal laws. The main law that this includes is Executive Order 11246. This 30-year-old order, signed by President Johnson and amended by President Nixon, applies to all non-exempt government contractors and subcontractors, and federally assisted construction contracts and subcontracts in excess of $10,000. Under Executive Order, contractors and subcontractors with a federal contract of $50,000 or more and 50 or more employees are required to develop a written affirmative action program that sets forth specific and results-oriented procedures to which contractors commit themselves to apply every good faith effort. The following are some examples of these federal affirmative action plans. For instance, the Federal Home Loans Banks provides for preservation and expansion of minority-owned banks. NASA requires that NASA administrators establish annual goals of at least 8% of total value of prime contracts and subcontracts awarded to be made to small disadvantaged businesses and minority educational institutions. Separately, states can establish their own laws surrounding affirmative action plans. The following are some examples of these state laws. Kansas, for example, allows Secretary of Transportation to designate certain state highway construction contracts or portion of contracts to be set aside for bidding by disadvantaged businesses only. Louisiana requires establishment of annual participation goals for awarding contracts for goods and services and public works projects to minority and women-owned businesses. Now, voluntary plans are another way of implementing affirmative action plans. Both public and private employers use voluntary action plans. However, both private and public employers must satisfy certain criteria in order to comply with Title VII. The employer must have a legitimate reason for adopting a plan. Also, the plan cannot unduly interfere with any employment opportunities for non-minority or male workers or job applicants to the extent that their interests are unnecessarily trammeled. To generalize about present unions, labor unions would be risky. In the past, several unions were explicitly segregationist and discriminatory, maintaining white-only hiring standards. The response of union leaders, whether from the progressive CIO unions or to the more conservative building trades, were generally the same. They tried either to deny the existence of internal racism by being anything more than incidental, blamed its existence on outside forces, or attacked the civil rights activists as racist, radical, and anti-union. To many racially segregated unions existed in the United States, and because unions had become ineffective in reforming themselves, affirmative action led by the courts took this power away from them. Although unions are now far less discriminatory in their hiring practices, much of this can be attributed to affirmative action plans.
One of the main arguments for affirmative action is the argument for diversity. Diverse environments are made of different backgrounds and human qualities varying in categories such as race, ethnicity, education, religion, and others. Diversity can provide exceptional benefits and unique learning experiences within universities and businesses, as well as discourage discrimination. In the mid-1960s, when these affirmative action policies first came out, blacks made up less than 2% of both lawyers and doctors in the U.S., and most of these were trained at all-black schools. Among the advocates of diversity in affirmative action policies was Professor Patricia Gurin of the University of Michigan, who strongly believed that exposure to diverse environments was essential during early adulthood, which was considered to be the most critical stage of individual development. In 1999, Professor Gurin participated in an in-depth study on the effects of diversity in classrooms. The study brought to light the empirical results of affirmative action policies encouraging diversity in classrooms. Positive growth occurred in such areas as critical thinking, problem-solving, and foreign language skills, and many others. The study also noted increasing interests in community activity and civic leadership. In another extensive study, two former Ivy League presidents, William Bowen of Princeton and Derek Bach of Harvard, set out to explore the long-term consequences of considering race in university admissions. This was the largest study ever conducted on this topic. The study considered 28 different elite universities, approximately 60,000 students, 2,500 of whom were minority students, over a 12-year period. This study considered the effect of race-conscious admission policies, that is, those policies that consider race to be a critical factor for admitting applicants to elite universities. The research found that blacks admitted under these policies earned advanced degrees at identical rates to whites and were even more likely to earn professional degrees in areas such as business, law, and medicine. They also became more active in civic and community activities than their white classmates and ended up earning up to 80% more than other black graduates. Also among the benefits, researchers also found that blacks and whites had reported much positive interaction with each other, which was instrumental in preparing them to relate to different races throughout life. Between 1970 and 1980, the amount of total black employment in the public sector had risen up 15% because of affirmative action policies. Between 1981 and 2001, the total number of degrees awarded to Native Americans rose by 151.9%. According to the reports from the U.S. Labor Department, affirmative action has helped as many as 5 million minority members and 6 million white and minority women advance in the workforce since its inception. And under a rough profile in the Bowen and Bach study of 700 black students, 225 were reported to have obtained professional degrees, 70 are currently medical doctors, 60 are lawyers, 125 are business executives, and over 300 are civic leaders with an average annual earnings of $71,000. By 1995, 7.5% of all law students in the U.S. and 8.1% of medical students were black, up from 1% and 2.2% in the 1960s, and were earning average annual earnings of up to $85,000, 83% more than other black college graduates worldwide. A more familiar story of the benefits of affirmative action would be the story of the first Latin woman to serve as a Supreme Court justice. Justice Sonia Sotomayor affirms that she is a proud and successful product of affirmative action. At AT&T between 1973 and 1983, the number of black craft workers had almost doubled and the number of black managers tripled, as well as the number of employed women increased dramatically due to the company's 6-year agreement with the Equal Employment Opportunity Commission. Similarly, at IBM, affirmative action guidelines spurred an increase in minority employments from 750 employees in 1962 to well over 16,000 by 1980. Bowen and Bach and many others claim that implicating a race-neutral admission policies in these schools could reduce the black representation in these schools from 7% to less than 2%. Affirmative action bans in universities in both Texas and California have had similar consequences. In the year 2000, the entering class at the UCLA Law School was decreased down to only 1.4% black from 10.3% in 1996 due to the passing of Proposition 209. An additional study by the Social Science Quarterly has also shown the devastating projected cutback in black and Hispanic admittance if affirmative action policies were overturned. A field experiment that was recently conducted by the National Bureau of Economic Research shows that affirmative action policies are still needed. The study found that based solely on resume testing and applying, applicants with white-sounding names were 50% more likely to receive callbacks than those with black-sounding names, even when qualifications were indistinguishable. The study also found that with identical improved qualifications, those with white-sounding names received 30% more callbacks than less qualified individuals with white-sounding names, but those with black-sounding names did not experience the same percentage increase. It is our position to continue to keep these affirmative action policies and allow the courts in the states to decide on whether or not it is time to overturn these policies. But for now, we believe it is not time to eliminate affirmative action.